I'm Scott Ott. And here's a thought. Ruth and Tony bought a nice house in a nice neighborhood, and they were so delighted with their purchase that they actually had the deed framed and they hung it in the foyer of their home. Although they loved the classic style of their home, it was a bit of a fixer-upper, so it wasn't long before they decided to change the wallpaper in the home to reflect a more contemporary style. "Honey, don't you just love this new wallpaper?" Ruth said. "Let's update the deed to the property to include this specific wallpaper so that it can never change." Tony tried to talk her out of it. "Honey, times change, fashions change," he said. "If we change the deed, then we'd have to go through a lot of hassle and hire an attorney to simply change the wallpaper. Why don't we leave the deed alone, and you and I can decide to change the wallpaper anytime we like?" But Ruth put her foot down. "I like the wallpaper the way it is now, and I always will." Of course, Ruth got her way, and the wallpaper design became part of the deed. Soon they had a similar conversation about the appliances because Ruth loved the avocado green and harvest gold appliances sold only at Sears. So they bought them, and Ruth insisted that these were the ultimate expressions of beauty. So they rewrote the property deed to stipulate that the appliances in this home should always be avocado green and harvest gold. Again, Tony put the deed back in its frame and hung it up in the foyer, shaking his head as he contemplated the future. Years passed. Tony and Ruth had 3 children. They continued to improve the decor of their home, but each time, at Ruth's insistence, they updated the deed to the property to lock in the changes in perpetuity. Eventually, Tony died, and Ruth had to move to a nursing home. She wanted one of the children to buy their home, but the kids took one look at the deed and said, "Mom, thanks, but no thanks. This wallpaper, these appliances, this decor, it's so old-fashioned, and the deed says that we can't change it." Ruth refused to change the precedent she had established in the deed, and the children would not inherit the home she had worked so hard to create for them. Supreme Court Associate Justice Antonin Scalia believed that the text of the law is the law, and that means that bad law should result in court decisions with outcomes that we don't like. The remedy to bad law, Scalia believed, is not to correct it through court rulings with their petrified precedents, but to change it democratically through the people's legislatures. Ruth Bader Ginsburg, on the other hand, believes that the Constitution is essentially crippled from birth because its parents were white male slaveholders trapped in primitive times. To atone for this original sin and its quaint constraints, the court should first consider today what it hopes to achieve, and then, in effect, alter the Constitution by reinterpreting it to achieve the desired outcome according to current fashion. The enlightened result of that judicial reinterpretation would be locked in by stare decisis, the court's bias toward its own precedent. In Scalia's view, you didn't have to reinterpret the Constitution to adapt to contemporary standards. That's because the Constitution already allows for progress through the process of democratic elections and legislation at the local, state, and federal levels. If Congress or the states make a mistake, they have to answer to the voters, and they can pass new law to correct the mistake. If Ginsburg gets her way, our children and grandchildren will increasingly view the Constitution as a musty relic from our ancestors that keeps us trapped in the past. If Scalia gets his way, the power to design and to redesign the future on a foundation that endures never leaves the hands of the people. I'm Scott Ott, and there's a thought.